Is that
This meeting is being recorded.
right? So we're on record. So we're just talking about the people that had came before me, and they had done a lot of the research to what's going on today, and there are many people that have come before me and have researched extensively on this project that we're on to, and we've now, after they had been researching for around about 10 years or 20 years, and I came in at the tail end, and then so they were able to give me all the information extremely quickly. And another person that I wanted to pay respects to today is Chief John Wanoa. Now, I know he gets a lot of flack, but he has research. It's not about who agrees with who. We agree with him or she agrees with us. It's about each of us has a great deal of information. Here's Liz. Each of us has a great deal of information, and we're putting all this information. Hi, Liz. Right, Liz is just connecting. Each of us has a great deal of information, and we're trying to connect up and find out the places that we do see eye to eye, and we're able to work together. We don't always agree. So Chief John and Chief Alfred, look at that.
How did you know that?
Yes.
I knew my name was being taken in vain, Kate.
Oh, yes, Liz is here. And Liz.
Sorry, I've been reading the case that you recommended. I've been reading the case that you recommended, Kate.
Okay, I'm just giving introductions first, Liz, just to say the people that we want to acknowledge that came before us. So Chief John and Chief Alfred, another person called Andrew Devine, who's working from England, and also Diane's partner, who is also English and living in New Zealand for many years. We've also got a lady called Rebecca, lovely lady called Rebecca, and she's from the Irish side, and my place. And then, so those people, those 4 people have been working for like 30 years on this. And their goal is to go to Westminster with their flag, and they have a little bit different goal to me, but they want to go to the head of the problem, straight to the head. And you'll often hear John talking about the big queen, the big king, and the little queen, which is in each of our countries, is the government is similar to a little queen, and they still have to follow the same directions as the big queen, and they're all accountable. And it's time that we started. So I'm plugging up the orifice, and he's going to tackle the head over there. So we're letting him do that. And all these people have worked for 30 years, and I've come in the last 2 years, and they've given me all their information. I've listened to each and every one of them, and I've gone and checked. And because of them, it makes it seem like I come in on the white horse as the savior of it all, when that is not the fact at all. There is decades of work in research behind this, and I'm only the one that came in at the very end and said, right, we've got all this information, and now what we're going to do about it. And we've called the Prime Minister to court, and we've called Prime Minister Ardern, the Minister of Justice, Chris Farfoy, and we've called Ashley Bloomfield, and we've called Chris Hipkins to come to the court. Now, Ashley Bloomfield and Chris Hipkins are very minuscule to this case. What we're going for is we're saying that this Parliament and the parliaments for the last 30 years actually have been working against New Zealanders, and they are currently out of control. and the people are suffering greatly because of this. So so we intend to go to the court, and we intend to remind them of what their oath, what does it mean to their oath of allegiance, what does it mean? Now, so that's the acknowledgement. Now, Liz has come in, and Liz, I'll just introduce Liz. I don't know if you want to show your picture or not, Liz.
Well, it might be a bit distracting because I keep looking at this at my computer, but I don't mind, just to show that I'm really here. There I am.
Right.
Hi, guys.
So this is, I'm very, very, very privileged to have the famous, everyone's been clapping when they knew that, when I said to them that you were coming, they're like, so this is Liz Lambert. And Liz Lambert is the famous Liz Lambert, who's done extensive work on many, many legal things, but many of the workers' rights. But Liz and I we're another people that haven't always seen eye to eye, have we, Liz? We've had some beauty arguments, but we are coming to a point, we're coming to a point where we're seeing that both of us have value, and we're putting aside the things that we, just like with John Wanoa and Alfred, we're all putting aside the things that we don't agree on, and we're looking at the things that we do agree on, and how we're going to be able to help people through that. And if we don't agree with what that person's doing, we just step back and we say, leave me out of that. And if it's something that we do find that we agree on, we work together on that. So Liz has been reading some documents. Liz, do you want to have a couple of minutes for the floor?
That'd be great, thanks, Kate. I mostly am reading the case that Kate pointed me to. It's the Attorney General against mostly Arthur Taylor. There's Arthur Taylor and there's 4 other applicants. And it's a very, very interesting case. It was in the Supreme Court in the end. And of course, it can't go further than that because we don't go up to the Privy Council anymore, but because it was supposed to basically replace the Privy Council, this court. So anyway, there are 5 judges, and Kate was referring me to, and I'm sorry, I just haven't had time to really read this case through properly, referring me to the 1688 Bill of Rights, which, you know, I have to agree actually in terms of where we're at is primary and fundamental legislation concerning what the 3 arms of government, the 3 branches of government may do in terms of carrying out actions, not so much against the people, but in the sort of law that can be made that complies with the rule of law. So I haven't actually come across that because I got involved in reading quite a lot of other stuff about it. And one of the, starting at, I think it's around about paragraph 97 of that case, because you can all get it online, no problem. Just put in a search, Attorney General versus Taylor. You might get different parts of the case because it was starting off in the High Court, went to the Court of Appeal, and then ultimately ended up in the Supreme Court. It was a case about voting rights for prisoners, actually, but there's a lot of really good stuff in here. Now, the decision went in their favour in the end, that they could, that it was a declaration, basically, that the Amendment Act, I think it's 2010, to the Electoral Act that denied them voting was contrary to, or you know, wasn't justified under the Bill of Rights Act 1999. Now, there was some really good stuff though that's said in it by Elias J. She's the chief judge there, and she talks a little bit about which I think might be useful for you, Kate, to read from 97 to 102 especially. I'll read the whole of paragraph 102 because it's so good. But she talks a little about the history of the Supreme Court, established 1841.
Can you wait for a minute, because I've got that case and I can put it up on the screen for everyone to see. Hang on, let me just, I should have had it really, but I do have it, so hang on. That's the groundswell.
Well, she talks about, first she talks about that existing rights are not abrogated. Now, we all know what not abrogated means, so they're not discarded, they're not pulled down, you've still got them. I think, you know, there's, Kate's got a lot of information about what existing rights are in terms of our interface, if you like, with the state. If you look at it, and she's putting it in terms of the 1688 Bill of Rights, which is a very interesting thing to do. I think it'll raise, I think the courts are pretty bored by all of this stuff, quite frankly, but anyway. So what's Elias J says? She said it was Supreme Court was established 1841. It got its name changed to the High Court in 1980. The Judicature Act, which is what the declaratory basically sets up, was same year as the Declaratory Judgments Act. That's actually what Kate will be using. And she talks about sections 2 and 28 of the Bill of Rights Act 1999, and saying existing rights are not abrogated, although they are not included. So if you go and have a look at section 28, I'm a bit more familiar with them. Bora, it will talk about all of those acts. I'm sure you guys are all onto this. Okay, so so I had a look at, what does she say? Section 2 of the Declaratory Judgments Act, and I actually wrote it down because I thought it's quite a good, you know, starting point. It says no act open to objection on the ground that it is a mere declaratory judgment or order sought thereby.
Can you stop there? What number's that, please, Liz? 97.
Yeah, started about 97, paragraph 97, where they talk. It's I think Elias J has the first, because they'll all talk on different
that's Elias CJ. That's Elias CJ talks first, and then someone comes in and talks after, but Elias CJ is first, and I think it's after that is Justice William Young, and so he's got something very important. Right.
Yeah.
Okay,
well,
so
I'll be
comment on her.
Excited to look at that. I got to get a life, but I'll be excited to look at that. Okay, but in terms of your things tomorrow, because you need a few sort of really socket to them points, Kate. Right.
Yeah.
So your Declaratory Judgments Act. What did they say? So declaratory judgments or orders sought thereby, and the said, I don't think it's in there because I went and had a look at the Declaratory Judgments Act. The said judgment sought thereby, and the said court may make binding declarations of right, whether any consequential relief is or could be claimed or not. So
What one is that on?
that's Section 2 of the Declaratory Judgments Act,
Oh,
1908.
yeah. So, okay, I'll just explain. The Declaratory Judgment Act comes from the 1808, doesn't it, Liz?
Yeah, 1908,
And
yeah.
what that's saying is that they can make binding declarations of right. What it means is that when you go to the court, they don't have to decide who is right and who is wrong. They don't need to say that the left hand is correct and should be and the right hand is incorrect, and or punishments or nothing. The only thing that they will make a declaration on is that, yes, this is one of your rights. And then you take that and then you take it to the ministers and you order them to stand down. And so when you call them, okay, when you call them to the, if you see here on 9, I have got a system that I want to go through, Liz, before I get to this, because I had it planned in my format to do some pre-teaching before we got to this, so that everybody knows where we're going. So I'll just, but I will say that in section 98, yes, section 98 is very, very good, because it does say that they can make an order and it binds anyone who is on the summons is served. We have called Jacinda Ardern and Chris Farfoy, and we're going to show you in a minute, because I'm going to show you in a minute, but their council has made the announcement to us that Jacinda Ardern and Chris Farfoy don't need to attend, because they're saying that they're not relevant to this case. And the reason why they're trying to weasel out of them attending is because if exactly what it says there in LESJ is that the declaratory judgment binds anyone on whom the summons is served. And we have served Prime Minister Ardern, and we have served Chris Farfoy and Ashley Bloomfield. So the council has offered up to us to send Ashley Bloomfield and send what's his name, Hipkins. They've thrown us an olive leaf of those two, but they've tried to let the big fish get away, which is Jacinda Ardern and Chris Farfoy, the Minister of Justice, and we're after the big fish here. So I'll just go through a couple of things of what Liz was saying. We're going to come back to Liz in a minute to give some background. I'll put up my share screen here, and I'll just turn that off. Andrew Little and Chris Hipkins, I think someone's just said to me, which is very, very helpful. So what I'm going to put up here first is the 1688 Bill of Rights, okay? So I'll go to my share screen. And if I share in my full screen, are you able to see this writing here quite well or not?
Might have to pull it up a bit. Oh, yeah, sort of. If you make it. Yep.
What if I do it in the individual? I think it will be better, I suppose, won't it? So let's try in the individual. So is that looking better?
Hang on, still coming up. Yeah, that's good. Can
right.
Pull it up a bit. Yeah.
Cool. Right. So this here is called the 1688. It was never called the Bill of. Well, it is called the Bill of Rights. We won't go there, but it is called the 1688, and we used the Will and Mary. And what some people, there's been some questions, and I did have it earlier, but you can go and research it. But some people have been calling it the 1689, and some people have been calling it the 1688. And they've been saying to me, if you use the 1688, that your case is already lost in the courts because you're using the wrong time frame. Well, this is not a fact at all. The reason why there's two dates of 1688 and 1689 is that the parliamentary times in the past didn't used to go from January to January. It used to go from, I think it was from March to March.
Oh,
And yes, so from March to March. So when, it was originally
the date
passed.
of the seat is the 16th of December, 1689.
No, that was yeah, okay. It actually passed in Parliament on February of 1688. That's when it was passed in Parliament in 1688. The bill was passed, and then in 1689, I think it was February, it was sent for ascension, which was in February, but February was still in the year of the 1688 time frame of Parliament, which ran from January to March or February to March, some time frame like that. It wasn't exactly the 12 months that we know. So they date it from the date that it was first passed as a bill, sent as a bill in Parliament. And that's why if you look on all the legal documents, they don't use 1689. But it actually, when our laws ascend to the Queen, they're actually ascending to heaven, because you'll see on here, if you go down here, I like to use the New Zealand one, but this is the old one with the old language, and it says here that whom it hath pleased Almighty God to make the glorious instrument of delivering this kingdom from popery and arbitrary power. I have to do this quickly because we've only got an hour. And what it's saying is that when you send this bill to the Majesty, you're actually ascending it to God. And if it doesn't pass the sniff test in God's law, then it will be sent out of heaven and sent back to the hells of the earth, because it's no good. So it has to pass that. So we call it ascending to heaven in Kate Floss's world. Now, you can see that this is the UK one. Australia's got one. Scotland's got one. Ireland's got one. But
we've got one. We've got it in our legislation.
Yes, it's here. Okay, I'll show you this one. So I usually work from the New Zealand one. They are exactly the same, but the New Zealand one is the easiest one to work from. It's because it's got big writing and it's not all bunched up. So you see here the New Zealand one, it says here that it actually commenced. So it was passed in the Parliament in 1688, but it got the royal assent of the heavenly tick from Almighty God on the 16th of December 1689. And so until that time, they were permitted to write their laws and prepare their laws as if it was law. But had it have been struck down, all of those laws that they were writing would have been striked. So this is why you can often see 1688 and 1689. But the true date when it was in the Parliament and able to be useful for lawmaking was during the 1688 parliamentary year time frame. And the true time when it came into being to the people to be bound by it as well was in 16th of December 1689. All right, so I'm not going to talk about that anymore because I don't want to spend all my time on that. But I will just say to Liz, I said to this is the, just going to do this quickly. This is the only means. If you want to remove Parliament, if you want to remove Queens, if you want to remove governments, this is the only means for you to do so. And that's why it's so precious to our people to keep this, because it is. And now, how do we remove them? Because it says here, here's the oath of allegiance, and it says there that this is when they make the oath of allegiance and to the supremacy that is required by law instead of them. So what it goes here, and it tells you in the frequent parliaments. All right, we'll go to just quickly the start here. In this one here, it says that this is God's law. So if you believe in Almighty God's common law, this is it right here. And so it ascends directly to God, and it bypasses the police, it bypasses Parliament, and it bypasses everybody to Almighty God. And all of their elections are based upon them upholding the oath to this law. And when they're not upholding the oath to this law, then you can write the things that they're doing wrong, and you can have them removed, either removed from Parliament, or you can have them at least suspended in Parliament, or you can at least have the order to tell them to stop doing the thing that they're doing that is against your right. And so it does say here that this is the best way that by the letters and elections being now, I'll go here. Lord spiritual and temporal and commons. So Lord spiritual are the very high up churches, not the peasants' churches, but the cathedrals and those places. Lord's temporal is all the royals, kings and queens, because Lord spiritual goes above them. And then under that goes the commons, which is the Parliament. Now it is the Parliament that they get elected. And this law is not for you, the people. This law is for them. They have to follow this law. Everybody is accountable to a law, and this is the law that they are accountable to. And it says that all their letters and elections now being assembled in a full and free representative of this nation, they must take into most serious consideration the best means for attaining the ends aforesaid here. Do in the first place, like their ancestors have usually done, for vindicating and asserting their ancient rights. Now, this is the job of Parliament. What they're doing is not their job. It isn't. This is what their job is, to protect us. Now, they have to follow all of these laws here. And one of the greatest laws that they have to protect is the subjects' arms, that the subjects which are Protestants may have arms for their defence, suitable for their conditions. Now, when they're saying Protestants, what they really meaning is the common law. And the reason why they have to be Protestants is because some of the religions believe that they should be the rulers of the entire world by their religion. So Protestants is the common law that can be suitable for Catholics, Jewish people, Islamist people, and also the people that don't want to be involved with all those religions. So they all come under these protections here. And one of the arms that we have, everybody thinks that arms are guns, but arms are not guns. Arms can be law. Law is a way of protecting you. And when they're bombarding you with all of these laws that are repugnant to the 1688, then that is a way of disarming you of your power. They're disarming you of your parliamentary power, because you have power in Parliament above them. And so that's what we're saying. And so when they come down to the frequent parliaments, and it says quite clearly what their job is, that they're there for the redress of all grievances. These are our grievances, and for amending, strengthening, and preserving the laws. Parliaments ought to be held frequently, and these are all the laws that they have to strengthen. Now it says here that they do claim and demand on the singular premises our rights and liberties, and that no declarations, no judgments, and no doings, and no proceedings to the prejudice of the people shall be had in any premises of the Parliament building, not by any of them. That includes, so I'm not going to go into the people. Now it says, when you have a problem with Parliament upholding all of these laws of your right, and we'll go to those rights in a minute, it says the only way for you to demand your rights and the only way for seeking a full redress is to go to the Supreme Court directly, and you ascend directly to heaven and you ask them for a declaration ordering the Parliament to stand down because they are not upholding the oath. And so that this is their oath is in here. Now it does have the requirements for the royal family, but we're on the New Zealand Parliament at the moment. Once they make their oath, it then says here that no foreign prince, no foreign person, no foreign state ought to have any jurisdiction or any power, so that's the United Nations, or any jurisdiction or any power over us. It is forbidden. And so that's the United Nations monster that's coming into our doors. And that's why they want us to throw this in the bin and bring in the 1990 Bill of Rights, because this one restricts their movement within our country. They can be in our country as a sidekick, but they cannot have power over us New Zealand people. So I think that's a good thing. And then after they've made this oath, they then go to the two houses will sit. And when the two houses will sit, that the Lord's spiritual, Lord's temporal, and the Commons, being the two houses of Parliament, shall continue to sit with the royal concurrence. And their job is to make effectual provision for the settlement of the religion, laws, and liberties of this kingdom. Now, let's remember that this is the common law, and common law applies to Catholics, Jews, Islamists, Christians, everyone. So this is the common law, and this is the religion of the common law that needs to be protected, so everybody gets protections and everybody's allowed to have their religions. Now, what you do that, as you saw there in the frequent parliaments, and that you can ask the Parliament to stand down by declaration, and you may go to the Supreme Court where the subjects' liberties are to be allowed, and you may request to the judge for a declaration to order the Parliament to order all ministers, all officers, and all parliaments that serve the majesties, their indubitable rights be upheld. And the judge will give you a declaration. We are asking for 4 declarations. When you get this declaration, that is the moment when the Lord spiritual, the heavens, and the Lord temporal, the nobles, have ordered the commoners, the common parliament, to get in their lane and step down. So this is the only way that you're able to do that. Now, when you come, there's lots of other stuff in there, but we're using this. This one is called the limitation of the crown. The crown is Parliament, and this is telling you what they must do in order to govern us. And it says it right here, that this is for preventing all questions and all divisions in this realm by reason of any pretended titles to the crown, and for preserving a certainty in the succession thereof, in and upon which the unity, peace, tranquility, and safety of this nation doth under God wholly consist and depend. That is, the said Lord spiritual, temporal, and commons do beseech their majesties that it may be enacted, established, and declared that the crown and the regal government of the said kingdom and dominions. So their whole parliament is rested on them governing us in unity and peacefully, tranquilly, and in safety. And they are not doing that. And these are the things that we're going to the court. Now it does say here that the Parliament's position, this is the Prime Minister that we're talking about. What is the Prime Minister's job? And that it says here, the Lord Spiritual and Temple and Commons do in the next, they're making a promise to us. We're not promising nothing to them. We have got to follow thousands of subordinate laws that they are ordering us. This is where they make their promise to us. And they're saying the Lord Spiritual, including the Pope, the Lord Temporal, including the Queen, and the Commons, which includes the Prime Minister and Parliament, do in the name of all of the people aforesaid, all of us, most humbly and faithfully submit themselves, their heirs and posterities forever to be under us. Under us, that as long as they're governing in those four places, unity, peace, tranquility, and safety, as long as they're doing that, we will work with them. But if they're not doing that, that is called governing in tyranny. And that is when we have the right to say, we're not with you, we will get our declaration. And if we don't get the declaration, then we will fight, because we're going to have to. And they do faithfully promise that they will stand to maintain and defend their said majesties. And also, when they're saying said majesties, that's us and the Queen. So we're all tied up together in a little ecosystem. It's not the Queen, it's not the Parliament, it's not the Governor General, it's not the people, it's not the tribes. We're all tied up in this little ecosystem that we all have to follow these laws. We are all accountable. They're accountable, we're accountable. And we're going to protect this with their lives and estates against all persons whatsoever that shall attempt anything to the contrary. And they are currently attempting to take over our country by the United Nations global machine, and that would be called the pretended titles of the Crown through the 1990 Bill of Not Rights. So that's about all I can say about that. Now, the last case, I'll probably just keep that one over there. And can anybody, if I move that, do you see my screen or do you not? And I can put that one off. So I will go to another screen, and new share, it says. So I'll stop that one. And I will go to another screen. I have to get through this very quickly because Liz has got such a limited amount of time. So we want to go to this screen. Now this screen here is the, this was the last time that the Bill of Rights 1688 was used in New Zealand, and it's time that we gave it another sending through the courts up to the heavens. And I'm not going to read it, but this case here is the Fitzgerald versus Muldoon, and he took Parliament to court and he won in 1 point. He didn't win in all points, and not everybody agreed with him. But the important thing that I wanted to say about this one was that this man, David B. Williams, he didn't agree with what Fitzgerald said, but he did say we should be thankful that Mr. Fitzgerald and his counsel, Mr. Barton, have reminded us of the Bill of Rights and of the principal and ministers ought to serve the Crown according to the laws. And what he's just saying is that's exactly what he's saying, what I've just said. They've got to follow, they're running this country as if they don't have to follow laws. And we need to remind them that they have to follow laws as well, not only us. They can't be sending their police out to beat people up in the street because they're not following the laws, because they are waterboarding us with their madness. And we all know that it's not right what they're doing. And they're beating people up in the street. So we need to remind them that, hey, you have to follow laws as well, not only us. Everybody's accountable. And so that's all I'm going to say about that man there. Now, I wanted to go to, so I'll stop the share for that one. And, okay, so we're going to go to the preliminary piece. Oh, I do want to go to just LSJ that Liz was talking about. And which one should I do first? I'll go to LSJ first, because this is going to come up in my case that I'm going to be showing to you, which we're going to be asking Liz's advice about any soon now. This is a very important case, because if you go, can everybody see that? If you go down to number 104, and this, in this case here, the counsel for Jacinda Ardern has said that I didn't recognize, because I said in my case that we are asking the Prime Minister to be suspended in her law-making activities presently, because they are governing incompetently and they're governing repugnantly to our law. And the council has said that I don't recognize their law. Am I on the wrong? Oh, I'm on the wrong case here. Oops. So, okay, this is a different case. That's not the Arthur Taylor case. Just a minute, I have to get my case right. Was it the Arthur Taylor case, Liz? Oh, it is. I've just turned this silly thing off. Oh, okay, I'll just get it, just 1 minute. Where's Arthur Taylor? Oh, he's down there. Here. Okay, sorry about that. We do have these little glitches sometimes. So I'll stop the share on there, and I'll start the new share. So is that the, can you see there, Arthur William Taylor? You can? All right. So
Yeah.
we're going down to 104. So this is important to our case tomorrow. Now, we're going in tomorrow, we're going in blind. We're really terrified. The main people involved with this case, we've got Jody and Diane, but they're coming in as observers. But the people that have been working really, really hard night and day on this case have been Maxine and Sharon. And also I want to recognize Melissa as well, who has been fundamental to the bringing all of this. She's the one that did the research for 10 or 15 years. So all of this started because of her. And another lady that I'm not allowed to mention her name, but I call them Fidget and Idget. They're two people that have been fundamental. I just want to recognize them. But the one that have been put in this case actually together have been Sharon, Maxine, and myself. And so if you see on 104, he does say there, they had said that he has said, the council has said that I've got no right to ask the Prime Minister to come to the court and answer to the people of New Zealand. That's what he's basically said. But luckily for us, the Parliament, through the Arthur Taylor case, was trying to get their declaration of inconsistent. What's that noise? It's a squeaking in my ear.
Is it somebody's thing is unmuted? Might be someone that is unmuted.
All right. Everybody mute. All right. So all right. So the Parliament, they wanted to get a declaration of inconsistency through the 1990 Bill of Rights. And they were the ones that went to the court, and they ordered that the Supreme Court has power to overrule Parliament if Parliament makes a law that the Supreme Court thinks is not justifiable. So it was actually Parliament and the Minister of Justice themselves that pushed through to give the Supreme Court more power over Parliament, where they said originally that they didn't have it before. Well, that has worked out perfectly for us, because he says such development is consistent with the statutory recognition that the High Court has the judicial jurisdiction that may be necessary to administer the laws of New Zealand. And he says laws which now include S3 and S4 of the New Zealand Bill of Rights Act. So he says he's not saying that it is his power is exclusive to the New Zealand 1990 Bill of Rights Act. He's saying that it is included in their other powers. And what are their other powers? Their other powers are the 1688 Bill of Rights Act, which is already that we're born with from England since 1688, all our children, and that all their parliaments and all their courts and all their queens and all their popes are rested on Almighty God's law. They're all under it. And we can take any one of them to the court when they are not upholding their oath. Even the Pope has to uphold that oath, and you can go to court with it. And this is how you do it. So he just said we've included SS3 and 4 of the New Zealand Bill of Rights. And if you're not familiar with that, that is the justified limitations, where they say they override a law of the United Nations, and then the Parliament says you're not allowed to have that law, and the United Nations says we think we should be allowed to have that law, and they go off to the Supreme Court, and the Supreme Court is permitted to overrule the executive on the decision that they made in regards to 3 and 4. You'll have to go and search. We don't have much time today, but if you want to know more about that, you can come on and ask me. But Liz knows it well, so I don't need to tell her about that much at all. So the next place that we're going to go to is directly to our case. And this is where we're going to be asking Liz for her wonderful advice. Oh, that's Maxine. I'll put that out. And, oh, I think I have to open it again, actually. Sorry about that. I'll just go and open it again. Just one moment. It takes me just a little minute. So the case is Mr. Moody. Right, so I'll go to, are we on share screen or not? Right, there we go, we're on share screen. So Liz, this is where we're going to ask for your assistance. So I'll quickly go through it and you'll know what I'm talking about. So you see here that the respondents are, in our case, we're asking for a judicial relief of our rights to justice, and other rights are not affected. And we've brought in Jacinda Ardern, Chris Barfoy as the second respondent, and we brought in Andrew Little and Ashley Burnfield. Now, right, so
can I just make a comment, Kate?
Yes, dear.
Are you going to put in, because they're talking about the Bill of Rights 1999 all the time. Can you just flick back up to the intitulation page, that first page? Are you going to put under the I'd suggest where you say, you know, you're looking for relief of your rights and that, right? That possibly would be under section 2 and 28 of the Bill of Rights Act 1999.
Yes, we've got all right, I'll do it. I'll start here first. I think it'll be better. Here's my statement of claim.
Right.
And you can have a look at it and tell me what you think, because I do really need your advice here.
What time are you going to talk to them tomorrow, Kate?
it's 10 o'clock tomorrow morning, so I'm very,
Okay.
don't have much
What time? Yeah, I've got
time.
it. I'm not in for the day either, but I am available by phone. But
I just want to show you because he has said that I have to rewrite it.
well,
And-
it's not up
and
to
I'm-
him. If
he-
the court wants you to, if the court asks you to do, then that's a different matter. He
Yeah.
has no right to tell you to rewrite it, Kate.
Yeah, he has threatened to strike me.
Well, I don't
And
know how he can strike you. He's just the Crown Solicitor. He's nothing to do with the court. He's not a judge.
Oh, well,
The Attorney General is just the other party, right? There's two
Yeah.
parties having a battle here. One is the Attorney General, and he's basically sticking up he's sticking up for their rights, what he sees are their rights.
Yeah.
And then you're the other party, you're the applicant, right? But the Attorney General can't say, well, we're going to strike you out. He might ask the court to, but it's up to the court, not to the Attorney General.
Yeah, he says that I'm not going to read my case to you, but I'll just show you how I've set it out, and and then we will go back, and then I have written the opposition to what he has to say, and I'm going to be asking for your advice if my opposition to him is correct or not. So so in my case here, we've done all of that. That's done. We have put in our applicant claim, and we have listed 10 things that are causing us trouble. We did the English side, and we also did, we've got my friend Sharon and my friend Maxine, who are both New Zealand Maori. So they're going to list their New Zealand Maori grievances, and I have listed my grievances. That is the statement of claim. We have 9 points that we've listed, and then we have listed, we have said there isn't any one cause. We're saying that the Parliament is bombarding us with laws every day, and we're saying that we're just giving an example of, this is a very rudimentary example of some of the things that they're doing, but there are many, many more above this. And this is just an example. So we've given cause for relief 1, and then we did a cause for relief 2. We wrote it nicely. And then we did a cause for relief 3. And then we did a cause for relief 4. We're going to be having more Zoom meetings going on about this, but we don't have time today. And then we've put our conclusion, and we have said to the judge that we don't intend for him to make any ruling of the above issues. We've said that they are just examples of what's causing us to be in stress. And then I've asked him for 4 declarations, and I have asked him for a consolidation of our 1865 Declaration of Native Rights that says that we will be governed by the order of the 1688. We've asked him for that the 1688 would be the law that S28 of the 1990 refers to. And we have been asking that all United Nations pre-1993 will not be included in S28. We're saying that they should not be because they are repugnant to S28. And then we've asked about, in the electoral law, I won't go over it today with you, Liz, but I will another day.
Sorry, Kate, why have you picked 1993 as your prior date?
Oh, 1990, sorry, 1990. Because it's, the 1990 was created in 1990, and S28 says all other existing rights are not to be affected by this law. but they didn't say that that included international laws. And in the Yardley case, they tried to attach the United Nations universal law to this, but the judge said you'll have to go to the Supreme Court and fight it out in there. And he said, I'm not making a decision on it. So I'm asking them to make a decision on it.
And I think Yardley says too that those international treaties are not good law in New Zealand. We can look
he said
at them. Yeah.
Absolutely not. I agree.
Yeah,
and he's right.
Absolutely not.
And he's saying, and this is why I'm on the warpath with the Employment Relations Act, etc., etc. He says, those principles have been incorporated in the domestic law.
He said it's come under workers' rights in the civil court, under workers' rights in the administrative court, not under Supreme Court. Or so, he said something like that. I could be wrong, but that Melissa is correct. Melissa's saying absolutely correct, aren't you, Melissa?
Well, they screwed over everybody else that's Indigenous. So you've got to look at that too, what they've done and what they're doing here, and they're sneaking it in, and they're going to screw them all over. I can see it. They already did it with Canada. I go all the way over there and look at all them and look what they've done. First Nations will tell you.
They're right.
I noticed this is I haven't had a really good look at the Constitution Act, the Constitution Act
1986.
Yeah, but they didn't. I mean, they had their chance then, and they didn't do anything about it. They left all of the imperial law in the thing, even though it seems that it was supposed to all be removed. So they didn't do it. It'll be interesting if they argue, in 1986, all imperial laws were null and void.
They had 30 years to put in protection.
Yeah. Well, I don't worry too much about what the other side is going to say. I tend to focus on what I'm fighting, and if you're fighting with the truth, you're not going to lose.
That's right.
Yeah, and he said, so now that you've seen that, Liz, do you think that it looks reasonable to you as a lawyer?
It's really hard, Kate, to to look at that and say, and make any sort of judgment about it. I would just say that, stick to your guns about you'll have a chance to rewrite any stuff. You'll get plenty of chances to rewrite stuff. I'll have a good look at it, when I've got time. But tomorrow, basically, I think if I can just refer you to a few paragraphs out of Arthur Taylor's case, right?
Yes.
And especially the judgment of Elias J., when she talks about that the submissions by the Attorney General were what she calls overly ambitious. Basically, you're talking crap. Okay, so what she says is, in addition, I also consider it is necessary to express my disagreement with what I consider to be an over-ambitious argument advanced for the Attorney General. It was argued that there is no breach of rights in the enactment of inconsistent legislation, since the legislation abridging the right has changed its scope. So what he is saying is, if we make a law that breaches your right, then your right is gone, basically. And then she says that submission, that was his submission.
What number is that? What number is that?
It's paragraph 102.
All right.
Yeah. And she says that submission denies the fundamental nature of enacted rights declared as such in legislation, and is inconsistent with indications contained, for example, in the Cabinet Manual. Now, the Cabinet Manual is basically the rules that the Cabinet has to go by, and they are considered part. The Cabinet Manual is considered part of our unwritten constitution, okay? So they have rules themselves that they have to go by. And all of this stuff that they've been doing over the 2020 COVID Response Act, they've been, as you say, Kate, they've been taking advice from all sorts of people. They haven't been cross-examined exactly what they were doing and what advice
Making up
they
their own
got,
crap.
what they got, what they know about the vax, etc. So what she says is inconsistent with indications contained, for example, in the Cabinet Manual, that legislation such as New Zealand Bill of Rights Act occupies a position properly described as constitutional. So part of our constitution, right? Nor is the argument easy to reconcile with the principle of legality. So basically it's that if you say, oh, well, we can make a law that takes away your rights and that's okay, that breaches the rule of law, because you can't have people making laws that take away other people's rights. That's because no one is above the law, and to do that is illegal, right? So basically you cannot make law or try and enact law that is a breach of fundamental rights, because what you're doing is you're acting as if you're above the law. Nor is the argument easy to reconcile with the principle of legality, which requires Parliament to speak unmistakably when limiting fundamental rights recognised by the common law. And it's got a reference to a case there. More importantly, I do not think that it is an argument that is consistent with the scheme of the New Zealand Bill of Rights Act. The Act requires legislation to be given effect when it is inconsistent with the rights contained in the Act, but withholds the legitimacy of compliance with those fundamental rights. Okay, so
what numbers are you on? What numbers you're on so I can let the audience see.
What she's saying there, you can get this act,
you can see it on the screen. Can everyone see it on the screen or not? If you tell me the numbers that the sections that you're using, everyone can see it, Liz.
Oh, sorry. It's 102, paragraph 102.
All right, paragraph 102. So I'm trying, Liz, to get more out of the fundamental right, and I'm trying to be more in the indubitable right, because the fundamental right can be
but that's coming down, Kate, that's coming down from the indubitable right. It's coming down. It doesn't just appear out of nowhere, right?
But the indubitable right is the supreme, is that right?
Yeah. Yes. Well, it's God's law. You know, you start off with the 10 Commandments and then you go from there, right? So more importantly, what does she say? The Act, more importantly, it's the scheme. The Act requires to be given effect when it is inconsistent with rights contained in the Act, but withholds the legitimacy of compliance with those fundamental rights. This is because Section 3, and she's talking about Bora, provides that observance of rights applies to acts of the legislature. Now, apparently, I was doing a little bit more reading, and New Zealand Bill of Rights Act is quite different to like the
Close
Canadian,
down your chats.
I think it's Canadian, and anyway, it's other bills of rights don't bind the legislature.
Right.
Ours binds the legislature.
All right,
It binds.
what do you want, Melissa?
Can you please close down your chat so we can read it? Thank you.
The chat.
Your chats are popping up. I'm trying to read it and it's cutting it out.
Is it, is
You
that
can
From
right?
the,
if you've got your computer, if you've got a computer there apart from your phone or something, you can just have a look at Attorney General versus Arthur Taylor, and you'll find it, and you'll be able to get it right up on your screen.
Yeah, so
This is
anyway, let's move on because we've got very limited time. and
basically
we've got a lot
what she's saying, Kate, is
to
that the legislature cannot make laws that breach fundamental rights.
That's
And
right.
the court, as you say, has the right to do something about that. It can make a declaration that you've made not just because it's usually left up to the Attorney General, right? But the Attorney General is part of the legislature or part of the executive, you know. And basically what's going on here is that the executive is grabbing all of the power, and they're actually pushing everybody else around, right? It's a total fascist move, right? But it looks like the courts have got an appetite now, because it has always been that, you know, because they'd always say, well, we haven't got a constitution, but we've got, you know, we haven't got a written one, but we've got an unwritten one. And in all of these documents, like the Cabinet Manual, like the 1688 Bill of Rights, like the New Zealand Bill of Rights Act, what else is in there? And they take notice of international treaties, but they're not part of our constitution, right? So those, you know, if you maybe could sort of, but they say that the actually, I think if we went for a new constitution, we might model it on the Australian one, because apparently theirs is really strict in keeping the powers contained within each branch, so that you couldn't get I think the Australians have been fooled badly too, but
Absolutely.
at least they've got a chance with their constitution, because it's written down, and apparently it's really strong.
Well,
even
We already know the government already have a written constitution waiting so they can screw us all over.
Well, we
Many
know
other
the
groups have too. I've
we know
read
that
them.
they're trying to make us inalienable, and I'm just not going there, and I won't even talk about it, because I know all the freedom movements are trying to get a new constitution, and I know that constitution does not include the 1688 Bill of Rights, and I know that they want us to have similar to the American Constitution, which is inalienable rights, which is very different from indubitable rights. And I won't even entertain the discussions of the inalienable rights. I only follow, I don't care about their constitutions. I only will fight for our indubitable rights.
I'm kind of warming to this, Kate. I'm actually going over to one of these meetings. That's where I have to go soon. But I will be talking
I wanted to show you what this man has said, so you can help me, Liz, before you go, because I'll be so upset if you're not able to. I just want to show you what he has said, so you can advise me. I know I'm just awful for asking you this.
Oh, is this Gunn, Mr. Gunn, is it?
Yeah. So I really need, because I've got to be in this court tomorrow, and I'm scared to death.
Okay.
So I'm just scared to death.
Well, no, you've got to say your prayers, Kate. What did he say? Where are they?
He says, first of all, he says that he will be the counsel to represent all 4 respondents. And then he talks about the time, don't worry about that. He says the respondents consider that, as it stands, the statement of claim is unintelligible. And he says, pleading to the statement of claim as it is presently drafted is likely to cause the respondents prejudice or delay, and is likely to result in a generalized statement of defense, which
well, hang on, stop there, Kate. Now, your reply to this is, we apologize to the court. Don't apologise to him, right? We apologise to the court. We
Hang on,
need
wait for a minute.
Yeah.
I'm
Okay.
gonna
Just make some notes.
and I have got a reply here, and I'm going to make notes of what you're saying to me.
Okay.
So I just give me a moment so that I can open that. So I have got the reply.
I can type
Brilliant.
what she says, Kate.
All right. We don't have to put it all in, Maxine, but don't disturb what we've done. But we will show her. But the things that Liz says to us, make a wee note, and then we'll show Liz what we've got, and Liz will tell us if she thinks that it's correct or not. Okay, Liz. So that is number one. What was the advice there, Liz? Sorry.
Well, he's saying it's unintelligible. Okay.
Yes.
So we throw ourselves on the mercy of the court, basically. We are not trained lawyers, but we know what's right, and we know we know the pain that that New Zealanders are going through, and we come to you because we recognise and butter them up, right? We recognise that you are the Supreme Court, and we believe that you have access and can do something about this, as what we're giving you as our prayer is the solutions that we've suggested in the last part of the document. Now, we are very happy to have your guidance, and I think you said, Kate, that you were going to ask if you could have a QC assigned.
Yes, but the way that you put it, have you got that there, Maxine? Maxine? Is the sound there?
Maxine might be
She's muted, but she's been there, thumbs up.
Oh, thanks, Sharon, because I can't see. Yeah, so that is beautiful. So she's got that. So we kind of got that, but we haven't got it put the way that you just said it, and it's just so clear and precise. And I think that's going to be valuable, and that's exactly right. So have you got it the way that she said it, Maxine? Because it was very nice.
She says yes.
Right. The next one, Les. He said the statement does not make it plain why the 4 respondents named should be named as parties. That is particularly as the claim alleges 3 political parties and others are relevant factors. To the extent, all right, I'll just leave, to the extent that he says I'm complaining about the COVID response and the first and second respondents should not be named. But we have presented to the court, Les, 3 petitions put in by other politicians, by Rawiri Waititi, Ted Johnston, and the Social Credit Party. They've put in 3 petitions to have our 1688 removed and have the 1990 Bill of United Nations rights entrenched into New Zealand law. And
well, why don't you cite those 3 then, Kate?
No, they're cited there in my case, and I have said to him, it's the Prime Minister's duty, because she's taken the oath to protect our constitutional law, our statute law. I've said it is her duty to order those ministers and those parliamentarians to strike them down, because that is her job. She's supposed to protect our rights, and she's not doing that. So I said that's why she should come to the court.
I don't know. Yeah, but I think actually, if they're the ones who've actually, you've got evidence there, right? You've got evidence that they are attempting to have us taken over. They are attempting treason, right?
Yes,
okay.
That's treason, yes.
So scrub out the other ones. what you've got to do is you've got to have evidence of stuff. It's never opinion in a court of law, okay?
I've
It's
got my
always
evidence.
So I think that those three that you've quoted, Waititi, what's the other two? Who's the other two?
Yeah,
Social credit.
here's one. Here's one from Ted Johnson.
Whoever's got their name on it, don't say social credit. You got it, because you're always remembering that when you're after declarations, you've got to make it personal to yourself. You are the ones who are the applicants. You've got to put you basically, the people that you want to put the finger on are those ones that you have evidence that they are planning something like this, and you know, and taking out 1688 and putting in things.
Yes.
So
We've put some
I would
evidence
change it to
here.
that.
Yeah, so we have said for that reason, that is the reason that Prime Minister Ardern should be coming, because it's her duty
I know.
to make sure.
I know, but sometimes, I mean, I know we all want to hang from the highest tree, but sometimes you do what is correct rather than what you want to do, right? You got. I think it would be a great case. I mean, she would be got at, because of course she's wanting to do all of this stuff, but we haven't caught her with the smoking gun. I mean, it's the same with people say to me, can't we get Jacinda put in jail? Not unless we can find her holding someone down and injecting them with a vaccine. You know, in the Yardley case, I mean, even Cook says that the reason that it's not a breach, it's not a it's a justified limitation, is because he talks about a prison case actually, where somebody was, he gives us an example, somebody was being force fed or forced hydrated, right? And now that was found to be a breach of section 11, was it, or 10? 11, because the person is actually in a situation where he has no, he actually is being physically coerced. Whereas, I mean, it's a crazy sort of reasoning. Whereas, in a case where workers are being told your job or your jab or the jab, they actually have a choice there. Okay, they can make that choice. That's what his reasoning was. So that's what I mean about the smoking gun, right? You've got to have evidence that the person is actually doing something that you're complaining of, and you've got to have it in writing. Now you've got it in writing.
We are saying that under the 1688 of ruling in unity, peace, tranquility, and safety, we're saying that she is not doing that. And
but you've got to have. Well, it doesn't matter. You've got to have evidence of her not doing it. I've got that leaked email that most people should have seen as evidence, right? That one, that email where she talks to Hipkins and Robertson and says, we're going to allow certain things and we're not going to allow, and we're going to hype up the numbers on the cases, etc., and we're going to bring in the military, and we've got the agreement of the Commissioner of Police and all of this stuff, right?
Melissa, that's your thing.
Yeah, but you've got to have 100% proof, and it has to be out there. If they put it out there.
But you have got 100%.
Melissa, you'll have to turn the sound off.
That is difficult, and it's too much for these guys. I'll tell you right now.
Yeah.
One day in the criminal court we'll get them, but in this case, you've got the petitions, you've got the evidence. Use those the social credit leader, whoever he is. Waititi, what's his second name? Or Rawiri, isn't it? Rawiri Waititi, him. And who's the other one?
It doesn't matter. It is irrelevant. We're not focused on any specific detail. What we're focused
Yeah, but
on.
if you're trying to push back at the guy who's saying, well, you know, there's no relevance to have
well, we've
thingy in
written,
there. I would agree with him on legally that there isn't. You haven't got the smoking gun with Jacinda. You have with these other guys.
I am saying I have got evidence, but I haven't been able to present it to you yet.
Okay.
But what
Well,
I'm saying is that the way that she's governing.
Oh, I'll tell you what. Where she gets on the TV, that interview that she has, and she says, yeah, we're going to make them second-class citizens. There's evidence for you, Kate.
Yeah, well,
you've seen that, eh? You've seen that one.
Yes, but we're not. What tomorrow is only the preliminary, and I don't think that they'll be asking us to present evidence. But
no, you haven't. Yeah, but if you're going to be there, it's going to be all oral. Okay, it's not going to be anything written down. But they are going to be looking at what the other side is saying. So you're going to have to say, okay, yeah, well, we will produce evidence of that she has been trying to divide the country. We have actual video evidence of it, Your Honour. Okay.
So we have yes, Liz, that's right. What we're asking for in our memorandum is that we're actually asking the court, this is what we're asking for. We wrote a memorandum to the court, and in our memorandum we have asked for a temporary suspension of the arbitrary laws that she is putting across. So we have put forward that there is the Three Waters, there is the Marsden Point, there is the 50% Parliament, there is the health thing that they're doing, and what we're saying to them is that this is a psychological waterboarding of law, that they're disarming us because we don't have time to fight them because they're changing the laws every 5 minutes.
Excellent,
So
excellent.
We had written this memorandum, and this was the things that we said, that I am petitioning the court to intervene in the New Zealand Parliament for ruling arbitrarily against the people of New Zealand since 1986, when the Constitution was removed with no referendum. So we've put that in for later references if we need it. The New Zealand public no longer have faith in the elections, as all parties have failed to hold Parliament accountable to their arbitrary laws, nor defended the indubitable right of the people. Nobody's calling it out. The New Zealand people are being forced to function under multiple legal systems, of which they are currently overwhelmed and distraught, such as hundreds of new subordinate laws in New Zealand, thousands of United Nations laws domestically, tikanga laws, omnibus laws, Waitangi laws, and so on. And the 66 bills are up for debate, and more than 154 petitions, including several instigated by Parliament, all with hundreds of laws attached and a great deal involving international issues that the people can no longer comprehend. So we're saying that they're not ruling in tranquility, that they're constantly every week throwing out something new, and we can't have time to get to the court anymore. Several petitions to remove our indubitable rights for our own parliamentarians and politicians, many who are not born to New Zealand. We're saying that the laws are changing daily at the flick of a pen, and it's the epitome of arbitrary power, causing public inability to function in their daily lives. And this is a fact. We pray the court to assert by declaration an unquestionable and certainty of law of indubitable right remains firm amongst the chaos of the broken New Zealand legal farce. And then we put in something for the Maori, and then we put in some various things of what they have been doing with Jacinda Ardern and Chris Barfoy. I won't read all that out because that's got quite a lot in there. But then we also wrote a reply to him, and in our reply to his, that he's saying that it is nothing to do with the Jacinda Ardern. We have said here, Liz, about Jacinda Ardern, we have said that the Prime Minister must have the opportunity, as is her right, to defend her position that she is strengthening and preserving the laws in parliaments that are held frequently for the aforesaid purpose by her oath. So we're asking her to come in and defend that she is using the oath as she should.
Yeah, well, that's
And
right.
then-
They actually do swear to defend the laws of New Zealand.
Yeah, they do. That's what but they're not supposed to be changing laws. They're supposed to be defending our right. If the respondent chooses not to exercise her right, and then then her position in Parliament may possibly be abrogated without her due indubitable right being observed. And then I've given them a reminder that this is not a criminal procedure, and it is a declaration that does not result as an offence under the law.
They're not allowed, actually, I don't think they're allowed to get themselves involved in criminal matters anyway.
Yeah, so he said he can't defend it. And I said there's nothing to defend. We only want her to come and let us know how she is upholding her oath. And then we said that she's supposed to I said that she's supposed to faithfully submit herself to the utmost of her powers against all persons that shall attempt anything to the contrary to remove our rights. And I've said that these political parties that have submitted petitions to Parliament, she has not defended against it. And Rawiri Waititi is a sitting member of Parliament under the oath himself, and he's a minister under her government, and she has not attended to the issue. So he shouldn't be in there if he's not upholding his oath. And why hasn't she? I'm saying the responsibility is hers.
I don't think that they've got a right to chuck people out of office, but I do think the idea that, and the main idea should be to push for a pause in their lawmaking abilities. We have more than enough law. In fact, if I had it my way, I'd get in there just the same as Trump did, and I'd pull all of the stuff out and give it a good shake and come back with about, probably cut the number of laws down by half.
Back to our 1608.
You like that one?
And we're saying that we're saying that the Minister of Immigration and the Minister of Justice is incompetent and unqualified for his position. And we're saying that he has imported thousands of refugees, he's giving out visas like candy, is what we're saying. And we're saying that he must have the opportunity to defend his position.
Yeah. Good.
As well.
Good. I like that. Yeah, I like that. Hey guys, I have to go. I'm sorry, Kate. I have to go. Send it over to me. You've got my email address.
All right. Well, we're going to have this meeting. We're going to have this meeting tomorrow at the court, but it is only the preliminary meeting where we're fighting our case that Jacinda Ardern and the Minister of Justice, who is incompetent and unqualified, Chris Barfoy, we're defending that they should attend the court and face the voice of the people.
They won't tomorrow anyway, Kate. So it's just I think tomorrow you should regard as a kind of a tidying up, of the issues, because they'll ask you, they'll say, can you tidy it up? Can you put it into you know, something that we can get our teeth into and that. But you know, mostly, you know, please, you know, go in and be humble and say, you know, we are here for the people of New Zealand. We are being, you know, as you've said, the peace and tranquility which is required, and probably if you look at if you've got a chance to look at the cabinet manual, you'll find that the, you know, because she's talking about it under, you know, the Chief
I haven't seen
Justice,
the
Anna
cabinet manual.
Myers, is talking
Send me
about this.
that. Could you send me the cabinet manual? I'd be very interested in that.
You can have a look. Just put in cabinet. Just put into your computer cabinet manual New Zealand, and you'll get it.
Oh wow, that's very great information.
It's in a PDF.
Wow. And is it long, Liz?
Let's see. Have a look. I'll just have a look. I'll see how many pages. 190 pages. So it's not lightweight. But just have a look at the sort of there's probably a précis or summary there somewhere about what it's for. So just get your head around, you know, what when you're talking about our constitution, we have got a constitution, but it's unwritten, and it's because people have never been taught anything about it that we're all at sea, you know. And we have to remedy this in the future. We've got to have civics taught in schools, that's for sure. But guys, I have to go. And thank you very, very much.
Thank you so much, Liz.
Okay, good luck tomorrow.
Thank
Thank you.
All right, so
10
there's only
minutes
10
left.
minutes left. I'm going to leave it open, but I'm just going to quickly show the picture up here that what we are asking the Parliament is for a suspension of their laws, and we have listed for all those people that have come on, we have made a list here of the laws that they are bombarding with us, and if anybody wants to add to this list, we're going to ask people to tell me now. So the first one that we had, that the government is charging ahead with the instituting of the United Nations Declarations of Indigenous People. The government is charging ahead with the Marsden Point refinery, and that New Zealand has paid since 1973 in excess of $190 billion. We have paid, this is the details are by Philip Bridge, who has given, he went and researched all of this and gave it to me. It took him a long time. And New Zealand has spent $190 billion on the Marsden refinery. There was an upgrade in 2015 at $365 million. And then there was another upgrade of $750 million, and in an expansion by Megan Woods. And now they want for the closure another $250 million. So they want 100, you know, it's like $100 million for expansions that only just happened in 2015. And 5 years later, they want the New Zealand taxpayers to pay $250 million to close down the Marsden Point refinery. We're going to be asking the court for a suspension of that for just for the moment, to give the protesters a moment to breathe, to just have a cup of tea and take a break. So we're going to be bringing in that. We've got the Three Waters, if anyone wants to send me any, we're only going to have a few minutes to speak in the court, but if anybody wants to send me some key details of the Three Waters, just in 1 or 2 sentences, we will add that to here. We're looking for finances, costs, and any distress, so that the next one is the He Pua Pua. We know that that's very stressful. They're saying that you're not going to have it, but they've said you're not going to have many things, and then they dump it on you. We've got the 50% unelected Parliament, Maori Parliament by Willie Jackson. We've got the New Zealand Health System and Health Department break up, and then New Zealand will have their healthcare by their race. We've got the establishment of 2 Mormon temples, one in Auckland, one in Wellington, in a small country of New Zealand. So if anybody has anything did I put that up to you? If anyone has got anything to add to that or details of that, we're opening up the floor. There's only a few minutes to talk. Come on ahead, anyone can talk. I'm opening the floor and being quiet now.
Sunflower's got education laws and Brent's got firearm laws. I am being harassed by police because I have bought 2 rifles in the last 9 months. You're mute, Kate. Kate, you're mute.
Who is saying that?
Sunflower, Melissa is saying education laws. And
Okay,
Brent,
can you put that in there, Maxine? Maxine, can you put in, add to that the education laws? What else?
Yeah.
firearms laws.
Firearms laws. Yeah.
The farmers' laws or the resource consent on their land.
The land
Yes,
thing.
yes.
Yeah, that on there, the land thing, yeah. The education that they're bringing in the homosexuality into all the schools, very excellent. That's a good one. What else? I mean, there's so many. We're going to put them on here, and we've only got a few minutes in the meeting. Unsure me.
Kate,
What does that mean?
unmute him.
Is it
Unmute him.
muted?
You
How
can
do I
mute
unmute?
you can unmute yourself, Brent.
You can unmute yourself, Brent.
It's a microphone in the corner, left-hand side.
On the right-hand side or left-hand
Oh, sorry.
side?
Left-hand, my one.
Scroll down, Brent, to the left side. There's a mute button.
I'm saying unmute. Oh, Joe Rosen as well. You can unmute yourself, Brent. Type something on there.
It's in the left-hand corner, Brent, of your screen.
All right, it's unmuted now, Brent. You can speak.
Connecting to audio. No?
Oh, it says you did not connect to the audio. You have to, I think you have to go out and sign back in. Oh, look, someone wants to be admitted. So, what happens if we want to make the video to continue for a wee while? Or will it not continue? Does it just go
It
off?
won't continue.
Don't forget you wanted to speak to Willie Jackson at something. Speak about Willie Jackson. You told me to note it.
Willie Jackson is bringing in his 50%. Oh, I can't remember Maxine. So, oh yeah.
Okay.
We're complaining about the erratic law changes and the Minister of Justice and the Prime Minister and Willie Jackson, their erratic law changes that they're putting on. Is that Kath? I'm sorry, Kath, because you can unmute your microphone by yourself. Kath, can you try and unmute your microphone?
Yeah,
Oh, yeah,
she
you
has.
can. Right, Brent, why can't you unmute?
He's gone out now.
The video's almost over, Kath, but we're looking at we're making a list of all of the things that the Parliament, all of the laws that we are disagreeable to, that the Parliament is laying on us. And so far on our list, we've got the UN Declaration of Indigenous People that is going to have profound powers in New Zealand, the Marsden Point Refinery, the Three Waters, the He Puapua, the 50% unelected Parliament by Willie Jackson. the health system with the race-based health system, the 2 Mormon temples, one in Auckland and one in Wellington, and we're going to have on there also the homosexuality being taught in the schools, and the new history that is false history in the education. And what was the other one that you just said to me, Jody?
Farmers.
Farmers.
Oh, the farmers' lands being taken away from them.
Not only that, the resource consents that they're considered that they have to apply for, and they're not even granted the resource consent, and then go to farm, it becomes unlawful. So there's laws there that they can't even farm.
Yeah.
Yes, so there's laws that they can't even farm.
Yep.
So what we're doing is making this list. Have you got anything that you want to add to the list, Kat Dodson?
Significant natural areas.
Yeah, significant natural areas.
Hi, Brent.
Oh, hi, lady. Finally.
There's about 4 minutes left, Kate.
On Brent talk. We can open up another one.
I'm getting smashed by the cops at the moment.
Why?
They're just hassling me hard out because I bought a 243 rifle and a 22 Magnum in the last 9 months. And because of my outspokenness, I'm just getting hard out harassed. And I told them that I've got them in a safe place, and I haven't actually met the police yet, but I've told them that they're in a safe place, and I gave them the guy's address who's also an ex-army guy, and they went round to see him where my rifles were in his gun safe.
Wow.
And instead of just viewing the rifles in the gun safe, they sat him down for an hour and interrogated him for a whole hour about me and how he knows me and all that kind of carry on, and and made him sign a statement and everything. So as soon as the cops left, he rang me up and said, come around and get your guns and get them out of here. And I don't have a gun. I've got no actual fixed abode at the moment.
Right, wait for a moment. Do you permit me to put that in our list of complaint tomorrow?
Yeah.
Without your name?
Yeah.
All right, I will put that in because that is comes under in the 1688 Bill of Rights, that comes under disarming the Protestants.
Yeah.
And that's what they're trying to do, to disarm the Protestants. And
Yes.
so we will say disarming the Protestants, and we will give your case as an example of how they are.
This is they've been round to my boss's house. They've rung my ex-girlfriend. They've run my ex-girlfriend's daughter, my ex-girlfriend's daughter's boyfriend. They've rung my dad. They've rung everybody.
They're harassing.
Yeah. Oh hell yeah. I'm at my
What are
wit's
they
end.
saying to those people? What are they saying to those people?
I don't know.
2 minutes left, Kate. 2 minutes.
Oh, okay, 2 minutes left.
This is what it's done to me. I've been so busy worrying about that, I fell for a roof.
Oh, wow.
Put a big gash in my hand with a nail because I'm just been stressing about this.
Oh.
Kate, could that come under excessive fines or legal and cruel punishment as well?
Yeah.
Let's have a look at our 1688 and see what we can find. So
1 minute left.
1 minute, and then we'll have to hook up again.
How do we hook up again?
All we'll do is I'll just I'll open up a new Zoom, and
She'll send you the link.
and I'll post it on the Maori Peons, and you'll all be able to come in. So
Okay.
I'm not sure that it does close off.
Thanks,
I think it
Melissa.
just goes on.
Thanks, Melissa.
I don't think it does go off. How many minutes is there, Sharon?
1 more minute. We'll see if it'll go off.
I actually, yeah, because it might not go off. I can
Here's
edit
hoping.
it. Oh, hang on, I can edit.
Well, it's 8 p.m. now. It should have gone off.
Yeah, it doesn't go off, I don't think.
Okay, carry on.
All right, I think it's just going to go on. So,
Yeah, well, if we get kicked off, we get kicked off.
is it 8 o'clock? How many minutes is it into 8 o'clock?
8 o'clock.
It's 8 o'clock now.
Yeah, 8 o'clock.
There are
But
changed it
I
for 3 hours.
I think Brent's case does come under cruel and unusual punishment because of the harassment and the what you call it, mentality, and he got hurt. He got
Does
hurt.
it to the 1688 Bill of Rights?
Wouldn't believe the stress I'm under.
And then
And the
What-
amount of backlash I've had from people around me over it, you know, like, it's just been insane, you know. People
you
just
can
don't.
go to the court. You can actually go to the court. Oh, hang on.
So this guy showed up, this cop showed up, and he had
Yeah.
another guy with him. The other guy wouldn't show his identification or nothing, and he was the one who did all the interrogating. And
Yeah.
I'm wondering if that guy was actually Secret Service or something like that, you know, Department of Internal Affairs or something. Because he gave no ID to anybody who they've come to see.
It just sounds like you think you're the only one, but there'll be many other people that this is happening to.
Oh yeah. But I'm
Brent,
definitely
Kate,
being
There
targeted.
was that pastor, wasn't there? There was a pastor that's been in the same situation.
yeah,
where-
yeah,
Yes.
you're right.
Yes. So
They-
that's
he-
good.
they went out
Pastor,
there.
That's right, the pastor.
They went
Because
out
that's
and
spoken, because the church had asked them to mandate, you know, the government had asked the church to mandate to have a vaccine, and he said no. And he was very, very vocal about it and very outspoken. And then next thing, he has had the police just in his house and interrogating him.
Yeah, he was in Christchurch too.
Yeah.
they just passed the terrorist act, Melissa said.
And what does the Terrorist Act say? Yeah, that is full of New Zealand migration law.
Really, it's actually very scary. The terrorist act that gives them the rights to walk into your house and search you and all sorts of things.
Is that 2020, Melissa?
I know that they put some in. I think it was 2019, 2020. They've updated it a few times. You just really have to. We have to have a talk about that. But yeah,
Yes, I'll put that in. That's very scary, that one.
Yeah.
You can go through your 1688 Bill of Rights, and what it says here is that the subjects which are Protestants may have arms for their defence, suitable to their conditions and as allowed by law. They're not allowed to disarm you and go into a place, because what is the law? What is the law that if you talk about with Brent, that the law said, what did the law say? The law says that one of the laws is that you have to have a safe place to
Yes.
keep your guns. And what he said
Yes.
is that he had his guns, and it says, so you're allowed to have arms as allowed by law. And part of that law is that you have to have a safe place to keep your guns, which is reasonable. And Brent had a safe place to keep his guns. And what the police did was went to that place, harassed and scared the person who was holding those guns in a safe place, so that now Brent does not have guns as allowed by law. now he has guns illegally because the place where he's living, he's not able to create a safe place. And so he had kept them at a safe place, and the police have gone and deliberately destroyed that. Well, that is called disarming. And that's what they've done. They have made it so that Brent can't follow the law that they had given. And so they went and destroyed that for him. And then now they've given themselves permission to remove his arms. And that's what's happened. And that's what happened in Christchurch too, didn't it?
Yeah.
So you can, what do you do about that? And what should the man do that he's raving on about? Nowhere in the 1990 Bill of Rights does it say that you're allowed to have guns. It doesn't say it. But if you go to here, you see it says you're allowed to have arms. And if they violated that, then you are permitted to make a petition to the court under the subject liberties to be allowed. And you can say that, you can explain that the police went and created a situation where you were following the law, your guns were in a safe place, but they went and harassed the person that was keeping them in the safe place, and the person had you remove the guns, and you are now not able to follow the law, and therefore you have to give up your arms. And that is they are disarming you, and you will get a declaration of some kind from the court, and order the police to stand down, that they have to give you an amount of time for you to go and find a new place to put your arms. But no, they're not allowed to come and take them away from you, because that's disarming you. So you could certainly get a declaration for that. And this is why we want to keep this 1688 Bill of Rights, because you are permitted to have guns under it. All the farmers can get together and go and get a declaration that they are permitted to keep their arms on their farms, so that these people can't come away and take their arms. So yes, this is a very important law. Any more?
To protect Brent, should he not get statement from the people, the army guy, have it written statement, because they can literally set Brent up.
Yeah,
That's
right.
pretty much.
You need to protect yourself with some statements, Brent, and have those somewhere.
Yeah, right.
Yeah, especially under the Terrorist Act.
Yeah.
Yeah.
They'll plant you. That's how they work.
Yeah. I've got something that I'd like to say, Kate.
Yes.
It's actually to do with the Codex Alimentarius, which is like a huge document again, and it's really hard to make sense of. But there is, and I don't know, would have to look into it. I don't know, someone else might know about it, but it is to do with hunting and gathering like wild food. Say if you go out hunting, wild meat or something like that, then it cannot be shared. They're calling it, you start bartering with it and things like that, it comes under commercial use, and then there's a whole thing that goes with that. So basically, if the system shuts down and people sort of become self-sufficient or whatever, they rely on their friends and neighbors and their tribe or whatever, they're not even allowed to share it with their family, because
that's why gardens too, they can't share their veggies at market gardens.
That's right. Yeah.
So is that been made into a law? Can I put that onto our list of complaints?
Absolutely, it is actually something
What is the law that I have to put on here onto the complaint?
They changed that a few years ago.
Type it up.
They just haven't enforced it. They changed it a few years ago. You're not even allowed to collect rainwater anymore legally.
No.
No, you have to have a permit.
That was 3 or 4 years ago, but they just haven't enacted the laws. They're sitting there inactive.
What's that law that Maxine always says? Sustainable what? Sustainable
development.
It all comes under that. Yeah, it all comes under that, Kate. sustainable development.
Yeah,
Yes.
It's restrictions and rules for wild food, they say. Hunting and
Yeah.
gathering wild food on our
and
land.
then,
But also they're poisoning it anyway with 1080. So, you know, they are actually, they are
And
just,
Diane, they're also shutting down all our local seafood fisheries. You look at
Yeah, not allowed
Kaikoura,
to go fishing anymore.
yeah, can't go to Kaikoura and get a feed of paua anymore.
yeah.
It's ridiculous.
Yeah.
They opened it up for 3 months and then shut it down again. And I've been diving out there, and like without collecting paua, and I've never seen such an abundance of paua at Kaikoura ever since they shut, you know, and yet they're saying that, you know, because of the earthquakes, it was ruined. The fishery was ruined.
Bullshit.
That's a big lie.
It
They've
is,
got
it's bullshit. Yep,
Yeah, they've got a reserve there that is huge, that everything can sustain itself.
yeah,
All the fishery can, every fishery can sustain itself.
yeah.
Yet they're shutting us down because they don't want us hunting and collecting. Due
Food
to
gathering,
the-
yep.
They
Yeah.
want to control our food.
Yeah,
Yeah.
and that is,
is
and
that in the law? Is that in the law? Then I
It
can
all
put
comes
them
under
up
that
in
sustainable development.
Development Act.
All right.
It's
So
all under the
you're not
same law.
allowed to, hang on. So you're not allowed to gather
Gather food.
food?
Gather food. Not allowed to barter with your neighbours for food,
Yeah.
veggies, anything.
Food?
so it's basically if the system did collapse, they are
Yeah.
taking away our right for sustainability, to sustain ourselves. That's the problem.
Yeah, right, yeah.
Lock us up in a smart city and we have to eat plastic food or ants and
I
you
watched
know.
a video on that today, Diane.
So did I.
Bill Gates has already heavily invested in it. They've got
Yes.
warehouses full of genetically modified
Modified
vegetables
food.
with nanoparticles. The vaccine are grown into the
The
vegetable.
lettuce, yeah, that's right.
Yeah.
Oh,
Yeah.
No,
Really?
no lie.
He's just given a grant to work on getting that mRNA into the vegetable.
Yeah.
Yeah.
Yeah. So we're going to be fed the actual layers upon layers of artificial lit warehouses where our food is going to be grown. So it doesn't even touch the true soil, light or anything. It's all artificial, and that's what.
Yes.
And plastic meat.
oh.
And up in Kaikoura, they've already started their social credits system, where if you go and buy a tin of baked beans, if you can buy 2, that gives you a point on your credit rating.
No.
Yeah,
Really?
yeah. It's already started in Kaikoura.
So if you buy 2 tins of baked beans, you get 1 point added to your social credit.
See, if you've only got $15 to spare, if you only got $15, and with that $15 you go and buy a tin of baked beans, but you need money for something else. If you can buy 2, that's a point added on for your credit
And if you
rating.
only buy one, you don't get your point?
Yep.
So
Okay,
obviously
so-
how they implement these things is they sell it to the masses as beneficial. You know, there's a good
Yes,
thing.
and it's
You go
not.
out and exercise and we'll give you some points, but it is for nefarious. I mean, once they implement the full, you know, system, then, you know, you are just basically full controlled, but they'll try and sell it to the masses as a good thing initially. You know,
Yeah.
it's all benevolent or whatever, but
Yeah.
yeah, we know.
Yeah,
we
'cause
know.
That, the thing is that we've got court tomorrow, and we can have these conversations anytime, but
Yeah.
I am scared to death, and I don't want this meeting to be about myself, but I am going into the lion's
Blind,
den,
yeah, blind.
and I'm a mouse. Now,
I
I'm
have-
trying to get this case organized and so that I can do it, and I'm
Let
not
me tell you
completed.
something.
And I've called this meeting for people to help me to
Yeah.
get this case in order. Now, it isn't in order. Now, we've got
Kate.
here, what?
Just listen to me for a second. I know a lot about going into courts by yourself and defending yourself. I've defended myself and been in court, the family court by myself, right? Have no fear. The judge is there to help you, right?
Yeah.
He will help you. If you are acting on behalf of yourself, the judge is obligated to help you through the court, through the system. And they do. They help you get through the system and get things right, say things right, and do things right. So don't feel scared. You're doing a wonderful. You've done a wonderful and are doing a wonderful job. All you've got to do is to just hold your head up and do like Liz Lambert said. Be very humble. Be very apologetic. Be very amenable, so that you're approachable and you're willing to learn and do, you got to kiss their butts a bit. But
Total point.
Well,
at the end of the day, you'll win.
Diane's talking. Diane, your microphone, you have to turn on, dear.
There was something that Alfred put up, which was a law document, and this guy he did say, if he offered words of wisdom, as to say, like a person going in as a common law representing themselves, he said to be as wise as a serpent and harmless as a dove.
Yeah.
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 Well, so part of my case is what is important tomorrow. Tomorrow is we're not actually fighting the case. Tomorrow, the council has put forward that he doesn't think that Jacinda Ardern and Chris Farfoy need to be attending to the court. He's trying to say that my case is about the COVID-19. And part of my defense of why they need to come is we're saying that they are waterboarding us with hundreds of laws in a very, very short space of time. And we're saying to them that even when we do go to court and we do win the case, not 5 minutes later, they've changed the law to a new law, which is the same thing. And we've got 3 examples of that. And one of the main things is that the main point, why are we going to court, is to ask the court to put a suspension on all of these laws for a moment to give the public a chance to get into the courts and fight their cases rather than standing there in protest and getting beaten up by the police.
Yes.
And so what we're doing is giving them the examples of all of the major. We're not looking for individual laws. We're looking for major laws that are affecting us that we're all not wanting to have. And we're saying that the New Zealand people would like to take a moment in time to go to the court and put their submissions of why they're against these laws. And I think that's what we're going to be asking for the judge. We're not asking for them to stand down. So it's very important that we have a good list here. It doesn't need to be too long, but it has to be significant. And we can't put it up there if it's just a willy-nilly conversation of the thing. We have to be able to cite the action that they're taking clearly and concisely. So let's pay attention to that.
Hang on, I'm going to go now, but just
now
as
you can go. Oh, great. Okay, we're going to go.
Hang on, just as a suggestion though, write down what you and Max need to write down for tomorrow. Other than that, you still have the 0800 number that they've given you for legal aid advice.
Yes.
Okay? And I'll catch up with you later on.
Right, bye, Sharon.
Yeah.
Bye.
All right. So we're going for a little bit. I just wanted to get this cleared up here of what we had, and we can take out something if we think. So,
the sustainable development is important to get across. The resource consent laws, the he pua, the three waters, these are all very important. Not because they aren't just one law coming in; these are multiple laws.
Yes, that's what I'm saying. I'm saying that.
Yeah.
I'm
They're the
saying
important
that
ones.
it's a waterboarding of laws. It is that they've already got them there. That we were not sitting at the table when they created the laws, and they've created them over several years, and now
Yeah.
they're just pushing them out left, right, and centre. This week you're over here on the left. Next week you're over there on the right. Next week you're over here on the left, and they're just every time you think you've got a handle on one thing, they just dish out a new thing for you. And this is called the waterboarding of laws, and it's a disarmament of your right to be able to use the law to help you and protect you, and they're using law against you. And so I have said to the judge, the applicants assert that the Prime Minister and the Minister of Justice, we are the applicants. We're saying that the Prime Minister and the Minister of Justice are acting incompetently by doing what they're doing. And we're saying that the laws are changing every day at an exponential rate, and that the people of New Zealand have had their indubitable right to function safely violated, and the religion's laws and liberties are in danger of being subverted. And we're saying that every minute that the Supreme Court allows to pass with these usurpers in control is what we're saying. So what we're saying is we're asking the judge right there on this day to put a suspension on this lawmaking chaos. Immediately. Immediately. We're not even asking for days. We're asking immediately.
Immediate.
And so we need, yes, so that's what we're asking for. We're saying that this is a judicial waterboarding that is occurring within New Zealand when their own, their counsel had complained that they couldn't read my submission. And I said that my submission is only 14 pages. So I said, how do you think that the public of New Zealand are able to read all of these hundreds of laws when you can't read 14 pages? I've said that to them.
Nice.
You can't read. Yeah, so I've said it's only 14 pages.
Yeah.
It
That's
surely
a nice
can't be that hard.
That's
So
using
I
your noggin.
Eh?
That's using your noggin. That's a really good comeback.
Yeah, so I have said the ministers of courts and the no parties, as they were all. Oh, I'm saying the people have no confidence in the Prime Minister, nor the Minister of Justice, nor the Minister of Courts.
There's a spelling mistake there. Yeah, got it.
Oh, find that.
Nor the current politicians, nor the political parties. We're saying we're done with all of them, as they all continue on the roller coaster of not upholding the statute laws of 1688, I mean.
Yes.
Therefore, the people of New Zealand are deeply concerned about the serious laws that are being changed in Parliament presently, and this is what we're asking for. A temporary suspension to give the public time to prepare and file their cases and check that they are constitutionally sound under the oath to Almighty God that their positions rest. The New Zealand public will to see that hundreds of thousands of dollars are not wasted. We showed them 3 cases, which are the Yardley case, the NZDSOS, and the Grounded Kiwis group, 3 cases that were submitted into the courts as complaint that midway through the case, Parliament just changed the law. And at the end of the case, after writing 200 pages, the judge said, oops, this is all irrelevant because the law has changed. And when they changed the law, all they did was tweak it so that it was not against what the judge, but they still continued with a new similar law, and the people just have to go back to the court and fight it again. So that is not the way that they're supposed to do their legal making, is it?
No.
So I have said, so those are the three cases, NZ, Yardley and Granite. So the list of issues, now this is where I need your help. And we need it to be clear and we need it to be concise. The government charging ahead with the intent of instituting United Nations, UN declarations of Indigenous rights and human rights laws and universal rights laws. So these are all international, which we have no power over. And I'll put in KII. You won't know KII. So that is one. And number two, I've got here the Marsden Point Refinery by Philip Bridge. That $190 billion was spent on building it, and $365 million and $750 million was spent on upgrading it, and they want $250 million to close it down. I think that's serious, right?
Yeah.
That's serious. The Three Waters, I don't have information on that. What is the problem with the Three Waters?
The Three Waters gives the government complete control over the water in New Zealand, all water plants. So it currently it's regionally.
Go slowly, because I have to type.
Okay. Currently, the water in New Zealand is owned by the people and the councils within the regions. Right. Well, what Three Waters wants to do is take that ownership away from the people and the councils, and give it to the and just completely take over control and operation of our water systems.
So that is owned by the people of New Zealand, right?
But
Yeah,
currently,
no,
isn't Brent, that, you
Sorry.
know, with the Three Waters, like with the DHBs and stuff like that, obviously they've broken down 20 DHBs, but some of those DHBs that operate on a local level, you know, they don't fluoridate their water. So once they get control of it, they will be putting, you know, they want to be fluoridating the water and all that stuff. So that's my understanding, that
Yes.
it's bringing in those resources and losing that local representation.
Yeah, it's taking it's pretty much all it is a hostile land grab, really. You know, and except it's water.
I'll put it a hostile. Shall I put that down in the lands one or up in the waters one? It's a hostile resource.
Yeah, it's a hostile resource grab.
Oh. So that is the hostile resource grab.
Just like the fisheries and everything else, I guess.
Yeah.
Along with the fisheries,
Yes.
the
And the hunting and gathering.
fisheries, and what was there? The fisheries and the forestries. And forestries. All right, forest.
Why are you saying forestries?
Do I put it or not?
No, I would leave that out, because our forests are, yes, they are foreign owned, but they're not been hostilely, they've been sold willingly. They haven't been taken over.
All right,
Um,
so I've got the Three Waters
They're
government.
being poisoned.
The Three Waters gives the government, I don't want to go down the Health Act, anything to do with that Health Act, it's just dangerous territory because once I let them take me into there, we will never get out of it. So I
Yeah.
don't want to go down there. But I've got here the Three Waters gives government complete control of the people's assets, the
Resource.
people's
Natural
assets.
resources.
Assets
Yes.
and
Assets of, yes,
assets
and natural resources.
and natural resources.
Yeah.
And natural resources that are
That's all that's needed. You don't need to go
owned,
further
yeah,
into it.
we don't need too much because the judge knows.
Yeah. Keep it
that
simple.
are owned by the people of New Zealand. This is a hostile resource grab. Do we need to have along with the fisheries or not?
No, you don't.
I don't think I need.
No.
I just said, because it's in quotes, I just said that it's a hostile resource grab.
Yeah.
So
Because that's a whole nother different ball game. The fisheries and the natural collection and stuff comes under that. The same as the vegetable growing thing. You know, you can't grow veggies and share them with your neighbours anymore. That's where that all comes into play.
all right, but that goes down there, so it's not up here. So the Hepurpura that we're saying, I've got this wrong. So I've got Judith Collins accused Parliament of working together in secret for 2 years.
I have nothing.
without-
I know nothing about Hepurpur.
Oh, it's heinous. It is just heinous. It gives it says that you New Zealand people have to pay for healthcare for refugees. You have to pay for housing for them. Everything is attached on. It's got New Zealand Maori, but then it puts and ethnic people, and then it puts they put all the refugees into and ethnic people.
Ethnic
And
people,
it just
yeah.
means everybody coming into New Zealand has got it's given them rights to houses. It's given.
Yeah.
Do you know how we let our New Zealand Maori have their own governance system because that is their right. That really was part of the treaty, and that is their right. But we didn't say that every single group could have their own governance system.
No.
And that's what they're trying. They want to have an Islamic group with the same governance system as we've allowed for the New Zealand Maori. They want to have an Islander group with the same governance system that we've given to the New Zealand Maori. They want to have a ethnic group and the Muslim group. So they all want to have their own governance system where they can have their own laws. Our New Zealand Maori have got their own tikanga laws because this is their country. And so they were permitted under the Constitution, Section 71, to have their own tikanga law according to each tribe as each tribe pleased, but as long as it was not repugnant. Now that was something that they should have because they should have their little space in the world that belongs only to them and to nobody else. But what they're trying to do is these other groups, the Islamic groups, the Jewish groups, the Islander groups, they all want to have the same thing paid by us, but all those people have got their own countries. There are dozens of Muslim countries that they can go to and get that. There are 8 islands where they've got their own islands where they can get that. The Jewish people have got Israel and they've got America. So they got those 2 countries to have that. So our New Zealand Maori should have that specific thing. That should be for them because that was part of the promise, but not for everybody else because we can't afford to give it to everybody else. So this is all comes under Hepurpura, and it was they created that with no public participation.
Fuck, none at all.
None at all. And that's and that is supported by Willie
heavy.
Jackson. Yeah, this is awful because you know, it's like, you know, you have a marae. We have a marae, and we pay for their cultural activities that they want to keep up their Maori songs and their Maori carving, and we pay for all that gladly because that is part of the culture of our country. But they want us to pay for each of their different ones to have that, and then it gets out of control because it isn't fair. And the funding that is allocated, so if you've got $1 million that we allocate to New Zealand Maori for these services for them, but when you add on the Muslims and their mosques, and then you add on the Israeli society, and then you add on the Pacificite society, that $1 million, only a very small portion will go to Maori because they do it according to number, and the greater portion will go to all the other organisations, and our Maori end up with nothing. And they're complaining about that now. So this is all through the He Puapua, is what will come into play under He Puapua. And one of the things that we pay for is for the New Zealand Maori to have their New Zealand Maori language. But in the He Puapua, they want us to pay for each of them to have their languages paid for and have a school in their own language paid by us in our country. So this is ridiculous, because then you're going to have, currently they have 25 Pacifica schools in Auckland and 3 New Zealand Maori schools, because it's done by proportion, and they are advocating for 50 more Pacifica schools because they have 8 Pacific islands, and each island has a different language. So they want their schools to be according to each of those islander languages. So this is very unfair to our New Zealand Maori, because it means that because I'm talking to Sharon, currently they can't get funding for their schools, because there's not enough funding, because all of the other ones that are coming in are sapping that funding from them. You see, so these are the things that are all in He Puapua and why it's so dangerous. Now, I'll just quickly say this now, because I don't want to go into this today, but the Declaration of Universal Rights, currently all New Zealand Maori land in its pure title is all the Crown lands are held by the Queen, and we can only get paper title. But that land is protected. All right, he's saying he's not sure if his request went on the list. Oh, all right, I'll have a look in a minute. I'll have a look at your request there.
Unmute, Joe, so we can hear what you've got to say.
What was the, I don't know if your request are survivors of.
Oh, hi. I just wondering, hi, I just went on and said, it's quite hard to say on the phone because I'm not very, I just had injuries, and there's sort of like, if you have sexual abuse injury before the age of 20, you just have to stay on a sickness benefit, and there's no opening for anyone who's been sexually abused, or consequential loss, or LOPE payments for people that have been mentally affected by pre-employment injuries. And the government's worded it so that it's absolutely impossible for anyone who's had an injury to get onto that list and make sure that they're looked after properly. They're stuck on sickness benefits for the rest of their life. And it's quite annoying, but they've just worded it so it's just absolutely impossible for anyone to launch onto getting any sort of compensation. So I'm just,
When-
if you guys can put that on the list, I know it's a complicated issue, but I've been listening to what you've been saying, and I've written notes down, and I'm just wondering how I can word it to suit my situation and everyone else's that's been in that predicament. But it's been a real, it's been listening to you guys, it's just huge. So that I've got a few
How do you
ideas.
think we can put this in? It's not something that I'll be honest with you. It's not something that I think is suitable for this, but because
too
I know
specific,
that
Joe.
this is so close to your heart, I'm going to put it in anyway. So
It's
I'm
a
going to put it
correct-
in for you, but we have to find a way. Now, I don't want to get into individual things because you know what I'm
No,
like.
I don't want to either.
But we have
What we'd
to
have to look
find a
at
way to relate this to all of New Zealand. It has to be significant, but I'm going to put it in for you because I know it's important, and I'm not going to be able to say much for you, Joe. But if I get opportunity in the court, even just to make one sentence for you,
That'll
that's
be
what I'm going
fine.
to do because you've asked me to. Right. So
Well,
how are we going to
wait,
word this? Ask Brent, he's good with words, right? Word,
Hang
Brent,
on,
sort this
hang on,
out.
hang on, hang on. I just want to go back to Joe there. The reason that that's too specific, you know, like we're trying to get a broad range view out. So that would come under something under the healthcare and all that kind of thing that we could look at down the track further, but not so much now. Now we just want that big broad view that envelops everything.
Yeah, I just want what Kate said. If Kate can do that, I'll just be over the moon because I'm going to have to be following it up on the next couple of weeks.
I'm going to put in a wee thing for you. Just I'm probably not going to be able to do much for you, but even if
No,
I can
that's
throw
fine.
in a single sentence for you,
Yes.
someone can help me to do this, help him to do it. I'll just throw in a wee sentence, and it won't be significant because all of these things I'm not going to be talking about in the court anyway. I'm only going to be saying, all I'm going to be saying,
No, I'm fine with that. I'll
all I'm
just.
going to be saying is a quick mention of each of these things, and let me try and put in that one there. Brent, can you help me try and put that one in there? I wouldn't usually use it, but if I get a chance, I'll just throw it in there. It's just a little bit, it's not going to hurt.
Someone else might
I
pick it up. Someone else might.
I
pick
would
it up.
kind of go down the path, Kate, of you've got to broaden this out. You can't just
What is
specifically.
the law? What is the
for the
law that you're
picture
talking
view.
about, Joe Rossen?
The law states that if you have an injury pre-employment, that you are not entitled to any ACC payments at all or LOPE, and you stay on a
What
sickness
is
benefit.
LOPE?
You have to have you have to have gone to a doctor at the age of 12 or whatever age to actually qualify to get lump sum payments or anything. Even though there might be heaps of evidence saying that there was an injury, you have to go and actually have, some people don't come till their
All right.
60s.
So when did they make this law, and which act is it in?
Yeah.
Oh, you caught me out there. I didn't know you were going to have a list on things that we could probably put on your notice board. So
Listen to me. This case doesn't go in until tomorrow, and so you've got tonight. And what we're looking for is a law.
You'd have to broaden that.
Specifically a law change where they had the law before and then
Just
they
an
changed
act.
the law. Yeah, and if you can send that to me, I'll put it in. And if you can't, then you try to think about, you see the lines where we're going down here, and you try to think about it. I can't just go in there and say ACC and that kind of
No, I
abuse.
understand that.
But if you can come up with me, because we're looking at things where the whole country is protesting. Like the whole country is protesting about Marsden Point. The whole country is protesting about Three Waters. The whole country is protesting about the lands being. We're looking for that, but that's not to say that you don't matter, Joe, because you do matter. And that, like Brent says, if we weren't so close to be going to the court tomorrow, we could deal with that, but we can't quite deal with it right now because we're a bit swamped. But if we can find a way to put that in there, so you've got all night tonight, and if there's something on my messenger, don't ask me to find it because I just don't have time for any of you. But if you can find it, you put it on there, and if it looks suitable, and it needs to be somehow connected to what we're doing, if you can. If you really can't, and you can think for short sentence, I'll put it on. Jody wants to speak. Jody?
So once you've got this case done, Kate, then it opens it up for everyone for doing their individual cases. So we need this case tomorrow to be this big umbrella, and we can do all the ones underneath.
I just didn't want to miss out, but we can do it at another Zoom meeting. I don't care.
Yeah. Well, this case, Joe, is that Jody said, all we're asking for is a declaration. We're asking for two major things. We're asking for a declaration to say that the 1688 is the supreme law over all of their laws. That is the major one. And the second one that we're asking for is a temporary suspension of all of the waterboarding of laws that they're putting on us so that we can have a moment to get these cases into the court. And when we've got that, that's when we can work with people like you, and we can do all sorts of things for you once we've got the declaration. So what we need to do, these declarations are for broad things that are to do with the entire country, and also not only for the entire country, but for future generations. Yeah.
Understand it.
Yes, dear.
Okay, I think you could throw something in there about, because a lot of the what has happened to us over the last few years has really affected all of our mental health. You could throw something in there about the detriment that what has been happening with all these law changes and whatnot has affected all of our mental health.
Yeah, so you've got 7-year-old
And that's beginning to go.
And
you've got 7-year-old children committing suicide.
later.
But just to point you in the right direction,
Come back
Joe,
on here, tell me, no, that's very important, and I want to write it in here now. So come back here, you're a bit ahead of me. Just remember, I'm writing this. Right, Brent, first, what did, look, we're not up to there, we're not up to conclusions. That goes in conclusion. Now,
Yes,
I'm up to looking at we're still on what the laws are. So we're up to the Hepurpua. Judith Collins is accused without public, with no supported, and that is supported by Willie Jackson. And then I've got the 50% unelected Maori Parliament. There's two of those, because one of them is the 50% Maori Parliament, and one of them is in June in Rotorua, where they're having the Maori councils, isn't it?
I have no idea.
Well, I'll just do the 50% Maori Parliament.
Are you including in that part there that with your 50% that they're not from generation born in Parliament, that they're actually illegally?
What's that, Jody? Can you say again?
They're actually illegally in Parliament because they're not born to New Zealand. They're not. Is that included in that?
Yes, I'm very good idea. I'm going to say they're asking for a 50% elected Maori Parliament, of which many people on the Maori electoral roll are actually Pacifica and not born to New Zealand.
Correct. Which is you're not allowed to do under the Bill of Rights.
No.
Roll's got 2 hours, Kate, instead of an E.
Oh, has that?
Yeah. Take the E out.
Thank you. So the 50% unelected Maori Parliament, comma, of which many people on the Maori electoral roll are actually Pacifica and not born to New Zealand. This is supported by Willie Jackson, okay? Is that right?
Yeah.
And then we've got the complete closure of the New Zealand health system and health to be divided up to the people of New Zealand according to their race.
What?
I wanted to put in the 2 Mormon churches there. The establishment of 2 Mormon temples, which is endangering the Protestant religion.
So is that funded out of taxpayers' money to build those churches, not out of the money?
No, but one of the things that when I get the declaration, I believe that all of the people that they're giving visas to have to have a letter from the Mormon church to say that they are Mormons. And those people pay 10% of their salary for so many years to the Mormon church for the visa that they've been gotten. It's a visa scam. And I know it is, but that's not for this case. But I do intend to make a case against the Minister of Immigration. And I think that there's a visa scam going on and they're getting visas based on what religion that they are. And trust me, the Protestants ain't getting a visa because they don't pay the 10% tithes. They want tithe paying people to come into New Zealand. That's what they're looking for. And so that's the money that is being paid to build these temples is actually coming from all of the 2 million people that have gotten their visas over the last 5 or 10 years that are members of the Mormon church. So when you've got Jacinda Ardern in charge of New Zealand, and then you've got her father, who is a devout Mormon in charge of Tokelau, Niue and Cook Islands, and then you've got her uncle, who is an Area 70 top member of the Mormon church in the highest levels running Samoa. And then you've got her other uncle, Vincent Halett, who is even higher than Ian Ardern running the American Samoa. When you put them all together, then you've got Alpito Williams Seo is a Samoan Mātai chief who was a Mormon bishop and then just suddenly decided a couple of months before he applied to be the MP of Auckland that he wasn't a Mormon anymore and went and became the MP of Auckland. When you've got that many Mormons running that amount of area of our countries, you've got to ask yourself the question, what's going on? Don't you? Right. So that's why I've said that. one in Wellington, Into a Small Country. Then I've got shall I put the homosexual and the new history education? And new history education in the schools?
I don't think you should put homosexuality. I think you should put LGBTQ.
No, I ain't using their stupid fucking words. They get the words that they've got. That's the words they got. I'm not using all these stupid letters because that's not good for the children. The kids think they're learning about the alphabet when in fact they're learning about things that they're not ready to be learning about. So I think that we should address it.
Kate. Let me tell you this, Kate.
Brent.
By saying homosexuality and new history education in the schools is not going to win you any favors with a judge.
I'll put the homosexuality on the other side.
That will not.
That is the correct name.
Because
That is the correct name. No, because taking transvestites down to the schools and teaching 4-year-old children, girls that they've got penises when they don't, and boys that they don't have penises when they do. Boys can get periods, and boys can. This is not right. No, it isn't. And I am putting in the fucking alphabet.
Listen to me. You're not fucking listening. Listen. That transgender is not a homosexual. It's a transgender. It's part of the LGBTQ fucking C people.
Yeah. They've got so many. You've got pansexuals, there's too many labels. You need to take it all under the LGBTQ, I think. Yeah, you're quite right.
I'm not doing that. So
you have to
tell me I'm not using their words. I'm not.
I'm helping. You're not helping yourself here.
Well,
you're attacking the gays. You're not attacking the people you want.
No.
New sex education. There you go. New sex education.
Yes.
I'm not using sex with the word children, so I'm not.
New.
There's no children isn't there. Children isn't there.
I'm not using sex in education.
Oh my God. You're gonna lose that one.
New history education and homosexuality, promotion to children.
No,
it's not, because it's just one. That's one of the arms. There's multiple sex arms.
Yeah, that's just make that is showing you to be totally what's the word? Homophobic.
Well, they can call me homophobic if they like. They all call me racist, and they can call me homophobic, and they can call me a smart mouth. I don't care what they call me, because I'm not going to play because listen, I'm 60 years old, and when I was a child, right through until I was 50 years old, we called it homosexuality and heterosexuality, homosexuality and bisexuality. That's the words that we have, because those are the correct scientific
this is 2020, Kate.
Just like you would call a woman a female, a man a male, and someone that doesn't know what they are is called a transsexual. Those are the words that we have, and those are the words that we will use them correctly in the correct scientific form that we're supposed to be using. That's what it says in the science books.
You're doing it wrong.
All right, let's not argue about that. The farmers' lands are taken. Let's move on. Farmers' lands. Move on.
Kate.
Yes.
Could you word it non-heterosexual?
Yeah. Yes.
Yeah.
That's better.
I like that.
You got to take that homosexuality out of there.
Yeah, because it's
Yeah.
all the different.
They
Yeah.
never used to mind. They never used to mind until somebody told them that it was
Right.
awful. They never used to mind because we always used to refer to it as that, and nobody
Yeah.
minded. It
Yeah.
was only when they came out with all this stuff that it's like nobody minded being black until somebody told them everybody hates the word black. But nobody thought about it when I was a child. I never even heard the word. So they have created that it is bad when it never was. And so I'm not going to say that I'm bad because I'm not, because this was the way that we always used to refer. But that's lovely what you've said there, Kath. I'll put it in and that'll stop the argument. Non-heterosexual.
Yes.
Yeah.
Non-heterosexual. Okay, this is good. The new history, they're teaching, I'll put teaching false history.
Yeah.
False history, education, and non-heterosexual promotion to children in the schools. Yes,
Oh,
I
I
think
like that.
that's nice, isn't it? Is that agreeable to
Is it
everyone?
hyphenated? Non-hetero.
Okay.
Yeah, just a little.
Oh,
yeah.
that's beautiful. Thanks, Kath. Thanks, Kath. That's beautiful. All right, so we've got that. Farmers' lands. Moving on. Farmers' lands.
Again, too many laws, resource consent, they can't operate.
Yeah,
Oh,
they can operate. Like apparently they need to
No.
have.
Yeah.
It's all right.
I-
You know, they're trying to get them in electric vehicles and these sorts of things, and they've got to go over the farm, and it's just not possible. You know, there's all
I-
sorts of things that they're making it unviable for them to farm.
I was the other day I was talking to a farmer who had 5 hectares of his land taken because his land became a SNA, a significant
That's the word I was looking for. Farmers' lands taken in
significant
NA. Yeah,
SNA. Yes,
I'll put it in. I'll put the correct word.
significant
And
natural area, and he lost 5 hectares.
Yeah.
natural area, and I'll put and an unviability to farm. Is that right, Diane?
Sorry, unmute. Yeah, yeah, unviable. It's. I mean, you know, it's the. Is it? I don't know what. If it's-
Unviable. This is going to be our only chance for all of us to have a voice to Jacinda Ardern and the Minister of Justice and the court. Everything that we say here is going to go down in the history books. So it's important that we get this right. Okay, because this is going to go in the records of history where 100 years from now, they're going to be asking what happened in New Zealand in 2020 to 2022. These are the things that are happening that are very significant. And so this is an important thing that we're doing for our country, all of us. It's important that we get this right and have it on the record books in the
Here we go.
correct way.
Change
So-
that wording. Change that wording there. Farmers' lands taken to in the significant natural area, and get rid of get rid of that unviable to farm due to resource consent.
Due to strict
resource consent.
Or is it?
Now,
Oh, it's the
what you've
resource
got to
management
do,
act.
you've got to try and match this. What you've got to do, I'm going to teach you something here. You've got to try and match this to the 1688. If you can match it in there and you put it in there, That comes under Almighty God. So let's go and have a look at our 1688. You can't see, but I can see. And see if
Yes.
there's any way 1688 Bill of Rights, and see if we can find something in there. Right, where are we? 1688 Bill of Rights here. And then we're going to think of, so we're on this, the farmers' lands unvoked due to strict, what was the end bit that you said there, Brent?
Unviable to farm due to strict resource consent. You've got it there under 10, under 10
Resource
consent.
consent.
Yeah.
And when what we're going to do is go and look at our 1688 Bill of Rights, you see, and see, because that's a very big one. Now, that comes under, if you know your 1688 Bill of Rights, that comes under forfeiture of person.
Yes.
And they're not allowed to forfeit your property. So we will put that in there. We will put
Creating
unvote due to strict forfeiture.
It's making it unsustainable, isn't it?
of person
with
due to-
no conviction.
No,
with
no, they don't put,
conviction
oh, yeah, due to,
in the resource consents.
okay.
Is it the
Should I
Resource
say
Resource Management Act?
Resource
Yes.
Management Act?
Yeah.
You know, and also like the fact is that they did a couple of years ago, and you probably know more about it, Brent, but because Jodie and I were talking about it, but where they actually went onto farms and they said the neighbouring farmers, you know, whatever there, they've got some disease and we've got to kill your animals.
Bovine disease.
Yeah,
That was terrible. They went to a farmer out here in Oxford, and all his people in the area would not let them onto his property. They all camped out on his out the front of his driveway so that the government couldn't come in.
Yeah.
And the government said either you take this deal and say nothing to the press, or what was it? They pretty much blackmailed him into consenting, and what he had to do was kill I think it was close to 500 of his cattle, who were all loved, you know, individually. His milking cows were all killed due to having this micro bovine plasma fucking something, and the poor guy, he was shut down. He could not it was terrible, and he couldn't go to the press because of the government blackmailing him.
How did they prove that the animals had the disease?
Well, the thing is, it's such a small disease that it makes no difference. You know, it's much like COVID in a cow. Think of COVID in a cow. That's what microbovine plasma, whatever it is. It's just it's a infestation that does not irritate the cow. It gets into our milk, but it is threatening to us within the milk. It was just a way for them to upset our food production again.
This is what they're going to do, Brent, to shut down. They'll declare mad cow disease. They'll declare all these things to get rid of all our animals.
That's why we're saying, that's why we have to get this court case in tomorrow.
Yes,
that's
we
what
know.
this is about. This is what this meeting's about, is to get this done. We've
We
got to
really
get it in.
need
I've got to send it tonight. Don't you see? It's got to
We
be
really
in.
We really need to protect our farmers.
So we've got to get this done, people.
Yeah.
Got to be in tonight, you know. If
Yeah,
I
well-
don't get this in,
I can sit up to all hours helping.
well, we have to focus. Right.
We are focused.
We want to get. We're focused on getting this piece here done because it's not done. There's many things to go over. This is only one small area. There are other areas, you know.
Okay, let's
Now,
move
are
on.
you in
then.
or are you
We've
in?
got-
If you're not, if
we've
you're
got-
in, you're
we've
in.
got- We've got the farmers' land one. Let's move on to disarming the Protestants.
Right, disarming and including their legal arms for their protections.
Well, you really shouldn't say that.
I mean that what I'm trying to say, you can help me to fix it. What I'm meaning is that when we speak about arms, it doesn't only have to be guns. Our laws of our indubitable rights are an arm that we can use to protect by going to the Supreme Court and by them and them making a law and then changing the law halfway through the court. That is a way of disarming people and confusing people. And so that's what I'm trying to say there. If anyone can help me to put that into the better words. Arms doesn't have to be only guns.
Oh,
You know,
Well,
arms,
you need, including the illegal arms.
I'm
Mhm.
trying to say that we can use, the law should be an arm that we can use to protect ourselves. And when they
You
remove
just put
that,
that in brackets by arms. You know how sometimes you just put it, the legal arms, and then you can put in brackets next to arms laws. You know, so that kind of covers that. It's not like you're sort of talking about weapons.
well,
Yes.
how do you want me to write it? Can you tell me, Diane? So
So
you
we
want
just
me
go
to,
back to including the illegal arms, and then just put in there next to arms, put a bracket, and then just do law in a bracket.
Yeah.
Laws with an S.
how can I say the laws, like, because what I've been noticing is that when they go to the court, they're halfway through the court case and the government just changes the law. And then they get the court case and the court case is useless because that law's been changed and they've just given them another law that then they have to go back and change it. I'm trying to express that. I'm not sure how to.
Yeah. Yeah.
and so disarming the Protestants in their arms, meaning the changes in the law, regular changes of the law,
Oh, lovely.
meaning regular changes in the laws.
By the stroke of a pen.
Well,
Oh,
Regular changes of the law midway
Mm.
through court submissions.
Yeah.
meaning regular changes of the law.
have you got a I'm sure you've got a case in point for that.
I've got 3 cases.
Okay, good. Yeah, that's good.
I've listed them.
Yeah, that's
in
cool. I
the-
remember you talking about them before, just making sure that they were the cases. Yep. All good.
I've already put them, so
Sit
they'll
down.
know what I'm talking about.
Instead of
So
meaning, let's say including, because actually we are allowed to have arms, whether it be guns. So just instead of the word meaning, put including regular. changes. Take the word
It
meaning out.
already has got including in there, Jody, as well.
Yeah.
You don't want it
already.
twice.
Okay, you don't want
Yes,
to.
yes,
It
yes,
just come up
yes,
with
yes.
another
You can
word.
just take the word meaning out. You can just take the
Meaning
word
out.
meaning out. and
Yeah.
it'll be good.
Yeah, that's
All
all
right,
right.
then, is that better?
Yes, that's better.
Right, disarming the Protestants of their arms.
And the
Like-
illegal arm. Not just
And-
arms, the
And their
legal arm.
legal
No, no,
arm.
no, no. You said you said including, put including. Take away that legal you did. Right, and put including.
Yeah.
And then take away the S on arms and just put arm. That means
I put
the legal arm.
legal arm of defence.
Just legal arm. That's perfect. And then
Right.
regular, and then you've got an
Right.
explanation of what that legal arm means.
Right,
and-
terrorist act. Terrorist act. What
Don't
is
you
wrong
want
with
to cover
that?
it both ways? You know,
Eh?
like,
But-
don't, just number 10, sorry, Brent, but don't you just want to cover both ways? You want it to sort of be the language that covers the legal arm, but also subtly covering, you know, arms to protect yourself.
That's what the first part I think does.
Yeah.
Diane,
I don't know why you've got in there.
disarming the Protestants of their arms is the firearms type of thing.
Yeah.
Firearms, that's
Their
the word I'm
legal
looking
arm
for.
is the legal side of things.
Yeah, I put firearms. That's fixed
Yeah.
it. Right, there you go, that's better.
Can you
right, so
take
this
in
time-
out too? In.
Eh?
Disarming the Protestants in of. You don't need the in.
Where?
Disarming the Protestants in of.
Yeah.
Is it in?
Oh, good. Right, there you go. Yeah, that is great, including their legal arm. Why don't, oh no, I don't want to stop this. I'm going to stop the video. Oh, it's not on video. Oh, the video goes off. No, it doesn't.